All right, folks, buckle up. We're diving into a Wisconsin court case where tens of thousands are on the line, reputations are on trial, and legal jargon is about to fly faster than you can say objection. Watch closely. This isn't your everyday plea deal.
We will go on the record in the matter 24 CF 169, State of Wisconsin versus Jennifer Rawls. The state appears through Assistant District Attorney, District Attorney Kevin Schmidt in person. We have Ryan Reed, Defense Counsel, in person, as is Ms. Rawls. We're set today for a plea and sentencing. The parties have reached an agreement. Mr. Reed, can you please recite the agreement for the record?
Thank you. Pause here. What they're talking about is a restitution agreement. That $87,850.94 isn't a fine from the court. It's money that has to be paid back to the victim. And by making steady payments, the defendant might dodge a felony. That's a huge legal carrot and a massive stick if she slips up.
Your Honor, District Attorney Schmidt, can you state the offer on the record?
Yes. Just about the length of it.
14 years, 8 months,
A little bit, yeah, 8 months.
total of $87,850.94 stipulated restitution.
It's actually 88,000. It's just since she has 1,000 posted.
I know that. I see that. Okay. And
Yep.
monthly payments of $500. Yep.
So it's the plea to that one charge as is, and then we amend into theft by employees. We do the DJOC on the felony theft, and then convictions on the misdemeanors costs. On the felony, that's the payment plan is described in there. It's $500 a month. It's got a $150 admin fee. It also alternatively lasts until she pays it back, meaning if she can do larger payments, she can get off of it sooner, which is the incentivization.
So she's pleading to the charge as charged, and you're adding 2 misdemeanor thefts?
Yes.
Yes.
So essentially, she's avoiding the felony if she does pay it back over this long period, and no matter what, she's been convicted of 2 misdemeanors.
All right. But with regards to the misdemeanors, what is the agreement?
The agreement on that would be costs. She doesn't have any AODA issues or something like that to give DOC to deal with, essentially.
All right. Ms. Rawls, is that the agreement that you've reached?
Yes.
Formal motion to amend to add 2 misdemeanor thefts.
So added.
Okay, so it's under $5,000, correct? I believe it is.
I think it's under.
I think they've changed it so many times.
Excuse me.
Yep, she's pleading guilty to the charge.
It's under 2,500.
Okay, under 2,500, and we're adding 2 misdemeanors. What's the statute? Do you have that?
Yes, it's just the misdemeanor theft.
Quick legal breakdown. These misdemeanor theft charges are essentially backup convictions. If she pays everything back on time, she sidesteps the felony. But miss a payment? The felony comes roaring back, and it's game. Over. This is what lawyers call deferred judgment with teeth.
Statute. So the penalty provision is 943.23A, and then otherwise the actual statute of the theft is the same as this one, which is 943.20 sub 1 sub B. Oh yeah, I said too fast. Sorry. The statute's the same as the original offense in terms of the charge, which is 943.20 sub 1 sub B, but the penalty provision is where it differs. That is 943.20 sub 3 sub A, which is under 2,500.
And you're simply going to amend on the record. You're not going to do an amended information.
If the court prefer I do the amended information after the hearing, I can do that.
I'm going to say in cases like this, Mr. Schmidt, I'd like that because I've seen a Washburn case that I'm on blow up because they just did it on the record and it got all messed up. And that was from 2013 And so it's hard to piece the cases back together. So if you can do that, I would appreciate that.
Would the court have any problem if I do that after the hearing?
Nope, after the hearing is totally fine. I just want it for connecting the dots in case. Okay, Ms. Rawls, that is the agreement, and your attorney has handed me, well, I have two documents. One is a plea questionnaire, waiver of rights form with attached theft by employee, trustee, or Bailey. I should have known you put the jury instructions because you're very thorough, and so I could have told the statute right there. So thank you, Mr. Reed. And he has the jury instructions and the other document that shows the offense and what needs to be proven. Do you recognize these documents?
Yes.
Did your attorney thoroughly go over these documents with you?
Yes.
Did he essentially go over them word for word?
Yes.
And so you understand everything on these documents?
Yes.
And with regards to the plea questionnaire, is that your signature on the second page?
Yes.
So your attorney went over with you what the state would need to prove your guilt beyond a reasonable doubt to 2 misdemeanor thefts, correct?
Correct.
And he went over with you the maximum possible penalties you face. Is that correct?
Correct.
Now,
This is the high stakes part. One missed payment, even by a day, and the prosecution can yank the deal. Imagine being 12 years into a 14-year payment plan and losing everything over a late check. Question for you: should the system be this strict, or is that the only way to make sure victims get paid back?
I also have the deferred judgment of conviction document with some of the terms, the more important terms were stated on the record. Do you recognize this document?
Yes.
And did your attorney thoroughly go over this with you?
Yes.
Essentially word for word?
Yes.
And so you understand everything completely.
I do.
And that is your signature on the last page.
Yes.
And with regards to the important terms, I'm just going to go over them again with you, that if the court accepts this agreement, that it would run for a period of 14 years and 8 months. Do you understand that?
Yes.
And after today's payment, you would owe $87,850.94. Is that correct?
Correct.
And you're going to make at minimum $500 a month payments, correct?
Correct.
And if they are late, if one of the payment is late, they're due by the 13th of every month. Do you understand that that's enough for the state to ask to revoke the agreement and to sentence you and enter judgment?
Yes.
Also, if you pay it off early, you can have the agreement go away and not worry about that felony anymore. You understand that?
I do.
Do you also understand that within 60 days from today, you must pay $150 to the district attorney's office?
Okay.
If you don't, that's the number one reason I see the district attorney's office asking to have these matters or these revoked and to set you for sentencing. Do you understand that?
I do. Do I pay that where I pay my ticket?
No, you pay that at their office.
Okay.
Okay?
And where's that at?
Very important.
Just on the whole.
Okay.
Very important you do that, and I would do it as quickly as possible.
I get paid Friday, so I'll do it then.
All right. So I have that you're pleading guilty to 2 counts of misdemeanor theft and 1 count as charged, theft of a business setting greater than $10,000 but less than $100,000. Is that correct?
Correct.
You're 39 years old. You have 12 years of school. You can read, write. You understand the English language.
Yes.
You are not currently receiving any treatment for a mental illness or disorder, and you've not had any drugs, alcohol, or medications in the last 24 hours.
Correct.
Because you're charged with crimes, you are entitled to constitutional rights. Each of these rights is listed on both of the documents on the first page. Your attorney thoroughly went over those rights with you,
He did.
and you understand them completely?
I do.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
I do.
That even concerns a deferred judgment of conviction. You understand that?
I do.
Do you understand, or do you need me to go over these rights with you in any more detail?
I do not.
You understand that you're pleading.
Listen closely here. The judge is spelling out the possible max penalty: 10 years in prison and a $25,000 fine for the felony. That's the shadow hanging over her head for the next decade and a half. It's both a deterrent and a constant reminder that the court's patience has limits.
guilty to a felony, if the court accepts the deferred judgment of conviction, this won't be applicable to you if or until the court enters judgment to sentence you. Do you understand that at that time, you would no longer be able to use or possess a firearm for life?
Correct.
You would no longer be able to vote in any election until your civil rights are restored.
Correct.
Those do not apply to the misdemeanor thefts, okay?
Okay.
All right. Do you understand that here, the state would have to prove with regards to the charge that it has been charged, that count 1, theft of a business setting, greater than $10,000, but less than $100,000. Do you understand that the state would have to prove on or around and between February 7th, 2023 and July 6th, 2024 in Burnett County, Wisconsin, by virtue of your employment, you having money in your possession greater than 10,000, but not to exceed 100,000, and you retained possession of that money without the owner's consent and with the consent to convert that for your own use. Do you understand that?
I do.
And do you understand the maximum possible penalty if the court enters judgment of a G felony could be up to a $25,000 fine, imprisonment of up to 10 years or both? Do you understand that?
I do.
As to both of the misdemeanor thefts, do you understand for each of the thefts, the state would have to approve, or it would have to prove that you had possession of, oh, wrong one, sorry, that you intentionally took and carried away with property of another. You took and carried away that property without the owner's consent. You knew that taking and carrying away that property was without consent, and you took and carried away the property with the intent to permanently deprive the owner of that property. And this is less than $2,500. Do you understand what the state would have to prove?
Yes.
And that's for both counts. You understand that?
Yes.
Do you understand the maximum possible penalty for each of those counts could be a fine of up to $10,000 or imprisonment of up to 9 months or both? Do you understand that?
Yes.
Do you understand that this court is not bound by the agreement reached between the parties?
I do.
Said differently, if I thought that there should be something different for a sentence, I can do that in my discretion. Do you understand that?
I do.
Do you also understand I do not have to accept a deferred judgment of conviction?
I do.
Do you still wish to proceed and enter a guilty plea?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Did you review this criminal complaint with your attorney?
Yes.
In particular, there is a section called the probable cause section, and it basically says what happened throughout that time and why you were charged with the crimes. Do you remember that?
Yes.
For the most part, are those facts accurate?
Yes.
Mr. Reed, may the court use the probable cause section of the criminal complaint to find a factual basis?
No objection, Your Honor.
Has anyone made any threats or any promises to you, Ms. Rawls, for you to plead guilty to these crimes?
No.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Has he looked at the defense or at the discovery, and has he discussed that with you?
Yes.
Has he discussed with you whether or not you have any defenses or a lack of defenses in this case?
Yes.
Has he discussed with you what could happen if the matter goes to jury?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or your attorney before I proceed?
No, thank you.
Mr. Reed, do you believe that Ms. Rawls is entering her plea freely, intelligently, and voluntarily?
Yes, Your Honor.
Do you believe she understands the rights she's giving up and what that means?
Yes, Your Honor.
Do you believe she fully understands the deferred judgment of conviction and how important it is to meet every single provision?
Yes, Your Honor.
Does she understand the ramifications of what could happen if she does not meet every single provision?
Yes, Your Honor.
Here's the DA's angle. This isn't about throwing someone in prison. It's about getting the stolen money back while still punishing the crime. Notice the praise for her accepting responsibility early. That's not just kindness, it's leverage in sentencing. The earlier you admit fault, the more bargaining power you have.
Any reason to believe she is not competent to enter her pleas?
No, Your Honor.
One last time, any questions for the court or your attorney?
No.
As to count 1, theft of a business setting, greater than $10,000 but less than $100,000, a Class G felony, how do you wish to plead?
Guilty.
As to count 2, which is now added to this case, misdemeanor theft under $2,500, how do you wish to plead?
Guilty.
As to count 3, the count that was added to this case, misdemeanor theft under $2,500, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of all 3 of those charges. As to counts 2 and 3, judgment will be entered. As to count 1, the court will hear arguments on whether or not to accept it. We are in victims' rights compliance.
Yes, Your Honor.
All right, argument, Mr. Schmidt.
Judge, these are always the hardest cases when you have an offender who at age 39 commits their first crime, and it's a really big crime. It's an embezzlement of a large amount of money from an employer that trusts them. The reason she was even in a position like that as a manager of this gas station is because she does have large ability to work and do a good job and get income. The amount of money is very large. Paying that back is a high priority, especially given the number of it. But it's too severe to just do a DJOC, which is why we have the extra convictions there. Those are her first convictions, and that will be a significant consequence to whoever itself, especially given what their convictions for. We really want to incentivize her to pay the money back. That's why we did the DJOC. I think she has high ability to pay in the future. That's why we're willing to do what I would wager is the longest DJOC ever done in the history of our office. We're willing to do that to make this business whole again. Another reason why we even remotely consider doing this is, this isn't just accepting responsibility here with the judge after you've been caught. She accepted responsibility when she was talking with the managers originally when they first sniffed it out. So this is really trying to restore the state of affairs back to where they were while still giving some accountability in terms of the convictions to this offender. Like I said, there's really no reason to think alcohol or drugs or gambling or any of the vices we typically see as drivers of criminal behavior here. The only thing the defendant alluded to when she was interviewed by the managers was issues relating to her son. Thank you.
Fines and other stuff. And that's what I don't understand is $87,000 in change is a lot to pay fines and stuff. So, but I'm hearing, at least from you, that there's no underlying issues to be concerned about as gambling or
Nothing like that.
addict who shops, a shopping addict.
And you have to remember, this isn't taking $88,000 out of the till. This is over a very long period of time. Something you commonly see with most people who commit embezzlements is they have no clue how much they took until someone adds it up and shows the receipts later, and they're like, oh my God, I took that much. So it's not uncommon to see this.
But it can't just be for fines and stuff.
I couldn't say. All I can say is it can't be traced to vices.
All right, Mr. Reed, argument and sentencing recommendation, please.
Thank you, Your Honor. I'm asking the court to follow the joint recommendation because I believe under the Galleon factors it's appropriate. This is a serious situation, Your Honor. It's a G felony. But I believe the public is better protected by Ms. Rawls working to make the victims whole. This is a case where she's worked hard to get the money that she's put into the clerk of court's office already. She's made a promise to make these payments. She's worked with prior counsel and current counsel to figure out a way to make the victims whole here. So I think that the community is protected by this. I think this is very serious. I believe that incarceration isn't going to help Ms. Rawls. Jennifer isn't going to help the public if she can't work to make the victims whole here. So I think under the Galleon factors, this joint recommendation is appropriate. Again, these are her first convictions. The deferred judgment, I think, is appropriate given her past and given her work on this case to work towards making the victim whole.